Yes, counsel. Good morning.
Good morning, and may it please the court. My name is Ryan Schiff, and along with Beth Eisenberg, I represent the defendant, Thomas Mortimer. On the threat of being stripped of his appointed counsel, the defendant, an indigent man facing 4 counts of first-degree murder, was ordered to pay the court $40,000, an amount he does not have and cannot access.
Well, he's got a lot of stuff, doesn't he?
He does not, Your Honor. So I think we can...
Well, maybe you can help me. Did he have cars?
No, he does not. The cars were in his now deceased wife's name, as was disclosed by the Attorney General last week. There were 2 bank accounts that were disclosed. One was disclosed in the amount of $500 as a joint account. I've learned that actually had $626 in it. And then there was a second account in his name that was disclosed as being $1,000. It's not in the record before you, but it is in the record in the trial court below that there is actually no money in that account.
What about IRA and college funds?
Yes. Well, I think an easy way to break down these assets is to think of the assets that are either, and this is all of the assets, are either the IRA or assets that are held either jointly with his now deceased wife or solely in her name.
The IRA was?
The IRA was not, so I think we can distinguish between those two. And if we talk about the stuff that was held in his wife's name, none of that, I think, can seriously be contended at this point to be assets that he can in any way access.
But can I ask you this? I mean, this case obviously is complicated by the Slayer statute. In the absence of the Slayer statute, we're really faced with a very different situation, aren't we?
Absolutely, but the Slayer statute makes all of that jointly held property and the property held in his wife's name absolutely easy to determine whether he has access to it. He cannot access it. The Slayer statute is perfectly clear. So long as he is charged with the unlawful killing of his wife, he cannot access that money. And it, of course, cannot be considered available funds.
To the college trust?
Yes, that was set up in his wife's name to benefit his now deceased child. So that clearly is not money that he could access under the Slayer statute.
Now, for the IRA, I mean, TAFDC, Emergency Assistance, Mass Health, they all consider IRA in determining the means of the person who's applying. Why should we be any different?
Because what we're applying is Rule 310. So we have to actually look to the language of 310. And if we do look to the language of 310, what matters is, as was discussed in the previous case, is available funds, which then turns us back to the definition of liquid assets. And if we look at the definition of liquid assets, and this is at page 45 of the addendum to the blue brief, it includes cash, savings accounts, bank accounts, stocks, bonds, certificates of deposit, equity in real estate, and equity in a motor vehicle or another tangible property. It does not include retirement accounts. Now, what the Attorney General wants to do is to say that an IRA is a savings account. That argument is in the teeth of the unanimous decision by the Supreme Court in Rousey versus Jackaway in 2005, which held explicitly that an IRA, and what they're doing is construing the federal IRA statute. An IRA is not a typical savings account. So the argument that an IRA is a savings account under this rule simply is wrong.
So you could, but you wouldn't, well, would you? Could the Commonwealth or could the court include, if it chose, IRAs in here? I understand your argument is really you just have to look at the face of the rule and yes, IRAs aren't included. But is there a reason we couldn't?
I don't think there would be any constitutional prohibition on it. I think that the court could.
You're not arguing the fact that you would have a 10% penalty doesn't mean it couldn't be looked at,
I think it could be defined under this rule as being available funds. I think then you would run into complications with ERISA, because if an IRA qualifies as a pension plan under ERISA, then ERISA does not permit state courts or any courts from alienating those funds. So if it's an ERISA-qualified IRA, then this court would not have the power under federal law.
But they're not alienating it. He can withdraw the money himself, subject to a penalty. All we're saying is that it's something that all we might be saying is that it's something that could be considered in determining what his assets are for purposes of determining indigency.
excuse me, I think there might be a distinction between determinations of indigency and what happened here, which is a determination that he was indigent but capable of contributing. Because that is an order that says you have to contribute money. What money do you have to contribute? The money in your IRA. So it would be.
I mean, just to follow up on Justice Fina, I mean, this is all hypothetical if one accepts your argument that they're not included now. But if one were to include it, it wouldn't be, the presumption could be they are included, and it would be up to the defendant to say, well, my IRA really is, it would violate ERISA because of my IRA.
I think the rule could be written that way. It's not.
Right,
I think I think, again, looking to the language of the rule, it isn't as though the drafters of this rule didn't have retirement accounts in mind. Now, if we look again at this time at page 44 of the addendum to the blue brief, for disposable net monthly income, that's defined as the income remaining each month after deducting income taxes, Social Security taxes, contributory retirement, union dues, and basic living costs. So if this rule were read to include as liquid assets IRAs, then you would be saying when you're figuring out what somebody's disposable net monthly income is, we're not going to consider the money that they're putting into retirement, but then turn around and take their retirement account. That would make no sense.
So you're saying is our rule needs to be amended. Shame on us.
I'm not, because I think that there is a
Doesn't
strong
want it to be
public
amended.
policy that was recognized by Congress in enacting the IRA statute in encouraging people to save for retirement and then not alienating that money.
But you're
And
not
this
saying
is-
we couldn't do it.
I think you could. And actually the bankruptcy statute, which was amended after the Rousey versus Jackaway decision, maybe is a good example of what the court could do, which is to say, yes, over a certain amount, I think for the bankruptcy statute, $1 million, you can look to an IRA as something that people have to contribute. But you're not going to go and take an unemployed person's $10,000, or in this case, $14,000, and force them to give up that only money that they have for retirement.
Well, present freedom may be worth more than future retirement.
That's true. And this is, all I'm talking about is policy considerations and considering any kind of revisions to the rule. As the rule is written now, the order that was entered below is unlawful and it has to be reversed.
And that's based on the view of the SJC's intent in drafting the statute to exclude bank accounts, to exclude retirement accounts from the meaning of bank accounts.
Well, I think what it primarily is the definition of liquid assets. That's what you have to look at.
Right.
And the only
which
thing
refers
that the
to savings
others...
accounts and bank accounts.
I'm sorry?
Which refers to savings accounts and bank accounts.
Yes, and the Supreme Court in the Rousey case said that an IRA is not a savings account. So
Right, but that was for purposes of the bankruptcy code and meeting certain definitions and focusing on age and all sorts of things that we don't need to consider here.
Well, that's only partially true. What they were doing is they were taking two statutes, the IRA statute, and they were taking the bankruptcy statute, and they were interpreting these things in conjunction with one another. What I'm asking you to do is to take the IRA statute and Rule 310 and interpret them in conjunction with each other. And in doing that, I think you should defer to the U.S. Supreme Court's interpretation of the federal IRA statute. It has nothing to do with the bankruptcy statute.
Can colleges take into consideration IRAs for purposes of determining whether or not a scholarship or a loan will be granted? And can banks take into consideration IRAs for purposes of granting loans to see what kind of security might be available?
I'm sure that they can, and I don't think there would be any prohibition on taking into somebody's account how much money somebody has in their IRA and determining their overall financial situation and making an indigency determination. But under the rule, as it's written now, that simply is not permitted. And certainly what's not permitted is what the judge did in this case, which is to enter an order saying that he had to turn over the money that was held in this IRA. And another place in the statute or in the rule where we see that the drafters were in fact thinking of retirement funds is also an income, because what the rule does for income, it says that it includes amounts received from pensions, annuities, Social Security, and public assistance. So what the rule does is says once you start taking the money from your retirement account, then that becomes income, and that is something that could be subject to an order requiring you to contribute. But before that, it is not treated as somebody's liquid assets and therefore was not properly.
You're equating the IRA with contributory retirement as well as pensions and annuities?
Well,
Isn't
I'm sorry, go ahead.
No.
If you look at the definition, I actually didn't quote it in its entirety. It's other earnings and cash payments, such as amounts received from pensions, annuities, and Social Security. I think that would, under
But with
any
respect
fair
to
reading, include
contributory
IRA money.
retirement, doesn't this suggest mandatory payments as part of the retirement system where that's required as compared to voluntary payments into?
It may, and there certainly are some IRAs that are mandatory. In fact, that's one of the ways that IRAs can qualify as ERISA qualified pension plans, is that they're
But
mandatory.
you're just saying
by
that's
employers.
not his burden.
That's right.
Okay.
Now, he paid nearly $14,000 into the trial court recently. Where'd that money come from?
It came from the IRA.
It did.
So he did liquidate the IRA and take the 10% penalty in order to show good faith and to avoid being stripped of counsel. He did that only after trying to get a stay of this order and having that denied, and on fear of having to proceed to trial on 4 counts of first-degree murder without the assistance of counsel. He did that, but it was done under duress, and he should have an opportunity to try to recoup that money since it was unlawfully ordered to be turned over.
So where we are now is Committee for Public Counsel Services representing him, but he is under an order to contribute $40,000, of which he has contributed $13,000 or $14,000. Is that what the status is right now?
That's absolutely correct, and there is no additional money that he could possibly contribute to this.
Where does the money go, as a matter of curiosity? Does it go to the general treasury?
That's what the rule calls for, yes.
Okay.
All right, thank you, sir.
Thank you.
Good morning again.
Why isn't this an easy case? With the Slayer statute really taking all the assets except the IRA essentially away from him, they're not available funds, why isn't that easy?
With respect, Your Honor, we don't actually have any evidence before the court as to the status of the college account or the bank accounts or even the vehicles. I think it's very important to clarify.
You gave us evidence
Well,
about the vehicles.
Yes, the vehicles, we don't have evidence as to the status of the vehicles, and I need to make it clear, I'm not advocating, nor did the trial court ever advocate, that those funds, any funds that are subject to the Slayer statute should be paid for Mr.
But the
What
court
how else
even
do you get
consider
to
the Slayer?
40,000?
When this case was before the trial court, none of that evidence came in. When there was the indigency hearing on September 9th, his ownership and ability to dispose of the cars, the 2 bank accounts, and his IRA were never at issue. They were never discussed, and in fact, he disclosed the cars as his, only his. And so the only evidence in the record regarding the college account, the attorney was asked, well, he has $38,000 in assets plus 2 cars, right? And counsel responded, he does. Later on, the attorney stated that he was the heir of the college account, but there might be, and I'm quoting from page 122 of the record, but there, quote, there might be probate proceedings to make him forfeit the funds. And then she goes on to explain that she's not a probate attorney. So,
Okay. So, and your argument, I take it, is this should and still can be raised below.
Absolutely.
You can come back and say, look, these are not available. You know, now we have all the documentation, they're not available under the Slayer statute, and that would resolve, if assuming that that's correct, that would resolve that.
right.
So the judge would have no discretion at that point but to change her ruling.
The judge would have no discretion to change her, but to change her ruling. I need just to qualify that. Under the Slayer statute, he's not 100% forbidden from inheriting these funds. If in the event he is found not guilty, he would still inherit the funds. So the judge would have the discretion to order him to repay the money in the future if he inherited them. That's not an issue here. I'm just answering that question for you, that the judge has would have to reverse her ruling here on the $40,000 if evidence comes forward that he doesn't have access to that money at this point in time. And I think this case highlights one of the discussions that we've been having in all three cases today, that it is the defendant's burden to come forward with evidence to establish his indigency. And in this case, he was determined not to be indigent on September 1st of 2010. There was an indigency hearing which Mr. Mortimer knew about on September 9th, 2010. He did not bring any of this evidence
It's in
forward.
custody, correct?
He is in custody, but he certainly could have spoken with his attorney and gotten information, given information to the attorney as to the disposition of the assets.
Could I just ask,
Yes.
with that, in that regard, that it's fairly neutrally written, the ongoing obligation of probation to determine, or it's an ongoing obligation to act if they have information. It seems to be written plus or minus, that is to say, not just, gee, he's got assets, but also he doesn't. So does this suggest that maybe a phone call to probation, somebody doesn't have a lawyer, they're incarcerated, say, I have this issue, I don't really have any more money, here's why I think so, then them to act, to just alert them to the existence or non-existence of assets, or depletion of assets, or more information about the assets they thought he had because he was wrong about the cars, for example? Wouldn't that place that investigation on probation once they've been alerted? I mean, if you don't have an attorney, how else are you going to do it?
The probation certainly does have a strong role in this case, in any indigency determination. They meet with the defendant, they explain the process to him, they go through and fill out either the long form or the short indigency form. And the probation department also is required to verify the defendant's information by checking with, under the old statute, checking with the RMV and with the Department of Revenue. Under the new statute, also checking with the Department of Transitional Assistance. That, if I'm understanding your question correctly, the probation department would absolutely have the obligation to alert the judge to that information. If there's a phone call to the probation department or a simple letter, a defendant in jail can write a letter and say, this is what my financial situation is. And he is the person who knows it the best. I thought I had $1,000 in a bank account, but I don't. Here's the account information. And I have written to the Bank of America, and they've sent me my account statement, and here it is, I'm giving it to you. Absolutely, a defendant could provide that information to the probation department, and absolutely the probation department must provide that information to the court. But the probation department, beyond what's provided in the statute, does not ever have the burden of disproving someone to be indigent or proving the person to be indigent.
Let's move to the IRA for a second. Let's assume that's the entire available asset source, the IRA. Can the judge, assuming he's not 59 and a half and has this readily available, can the judge order him to liquidate his IRA and turn those funds over?
Yes. Okay. The judge has the authority to
where does that come
from? Because an IRA does fall within the definition of a savings account. A liquid asset is defined to include both a bank account and a savings account.
So there is no distinction, in your view, between an IRA account, which may not be a bank account, frankly.
Right.
It could be in any number of different vehicles.
Absolutely, and that's why I believe that the definition of liquid assets refers to both bank account and savings account. Otherwise, you wouldn't even need the term savings account.
Is there any evidence other than what you just said that you think bank account would include savings account, so you wouldn't need savings account? I mean, is there any other basis on which you say that an IRA is a savings account other than what you just said?
Well, I think besides that and the ordinary understanding that a IRA is a form of saving for retirement, Massachusetts case law in the family law context repeatedly considers an IRA an asset, unlike the argument that this is somehow deferred income or it's not income at all or not savings. In the family law context, it is considered an asset, and it's also referred to as a savings account. So that certainly supports.
It may be considered an asset in the larger realm of things, but if it's the only asset, can the judge order that it be liquidated and the money paid over?
I think the starting point is that a defendant does not have a right to publicly funded counsel unless and until he can show that he cannot afford to retain one himself. So it is appropriate to ask a defendant to look to all of his resources before coming to the court. It's certainly within the court's discretion to say, I'm not going to leave you destitute, and if this is your only asset, the court could make that consideration. But that is up to the discretion of the trial judge for her to look at the entire financial picture. And in fact, there's no public policy reason to treat an IRA differently than any other savings account.
Well, there's a tremendous public policy which has been articulated time and again in Congress and elsewhere about ERISA plans and preserving these kinds of assets, keeping them creditors and others away from them. I mean, there are tremendous public policy implications to these types of plans. That's why they exist.
There certainly are public policy reasons for keeping them away from creditors, but that's not what we're looking at. We're looking at a person having to pay for his own counsel, and does he have funds to pay for his own counsel? I put $50,000 in my IRA. My neighbor puts $50,000 in the Bank of America savings account. There is no legitimate reason that I should, because I chose to get some tax benefits, that I should get counsel and my neighbor shouldn't. We both have available to us funds with which to retain an attorney, and therefore neither of us is entitled to appointed counsel.
Now, using that analogy, do you agree that in terms of calculating the amount available, the IRA should be viewed as $45,000 because there'll be a 10% tax imposed upon the $50,000 surcharge?
The IRA is how much? $14,000, right?
I think he was using my example.
I was using your example of two separate accounts, each for $50. When the judge is calculating how much is truly available, would it not be appropriate to say, well, there's only $45,000 available because there'll be a 10% surcharge?
Absolutely. If the defendant comes forward and shows what the penalty is, absolutely, because he obviously doesn't have access to that 10%.
What about, can a judge also discount it for tax purposes, the amount of tax that will be due on it?
The entire purpose of the indigency evaluation is to figure out how much a defendant has in order to pay for counsel. So if he doesn't have that money because he's paying it in penalties, he's paying in realtor fees.
So a judge can take into consideration the amount of tax that will be owing as a result of the withdrawal of the money from the IRA.
Oh, I'm sorry, I didn't understand the question.
It seemed to follow from what you said.
It seems to follow. I don't think the rule actually provides for that, but in this instance, for example, he came forward with $13,844. That is what he was able to.
Right, but he will be assessed. He will be assessed a surcharge, and that will be viewed as income. I'm sure that's not his primary concern right now, but that money will be due and owing by the IRS at some point, depending on his income.
I have to say that's a question that I haven't contemplated, but I think that goes a little bit too far afield from considering available assets. His later tax debts, I don't
think there's
believe
any.
should be considered.
The record shows he has no income, but if he did come forward because he had other sources and could show that he would be paying taxes, it seems to me the available part of the rule would require the judge to consider it.
Well, and just to clarify, liquid assets does not include the word available. A lot of people have referred to available and accessible. Those terms are not aren't in the definition of liquid assets. I see my time is up. Thank you very much. I'll rest on my brief.